Ladies and gentlemen, the story you are about to hear is true.
Motor Vehicle Administration versus Pollard. Nice to see you, Mr. Merkin.
Nice to see you, Chief Judge. Good morning. May it please the Court. We are here today on behalf of the Motor Vehicle Administration as to an issue that was just recently decided and written eloquently by Judge McDonald in the Kraft case. Is in a test refusal case whether an officer has reasonable grounds to believe the person was driving, and the question that this ALJ took in this case, that actual driving or had driven was the issue, and whether Atkinson applies. It's our statement here that the factors of driving do not apply in a test refusal case. 16205.1 F7 clearly states that in the refusal case that driving is not an issue. It's whether the officer had reasonable suspicion. I think the argument of the respondent, Mr. Chhabra, in his brief and before the circuit court and before the ALJ was whether, because this was a trespass complaint, whether the exclusionary rule applied. And this court has made clear in Richards that there's no criminal exclusionary rule. That this case is whether, as was stated in Shea, reasonable suspicion is a common sense, non-technical conception that considers factual and practical aspects of daily life and how reasonable and prudent people act. And whether the police officer can use the inferences, in this case, coming upon Mr. Pollard, who was in a remote area, had driven, well, it is the police officer's inference that he'd driven to this house, was texting an ex-girlfriend to the point that she had called the state police with a trespass complaint. The state police officer came, and it was Mr. Pollard's testimony at the administrative hearing that he was awoken. He was angry when he was woken up. These are the inferences. In the DR-15A, the trooper put in there that there was a strong odor of alcohol on his breath and upon his person, that he had bloodshot eyes, that he had slurred speech. All of these factors led the trooper to the reasonable inference that the respondent was driving under the influence of alcohol. And that's all it is the reasonable suspicion. In this case, the administrative law judge went away from the finding in the Kraft case and looked to the factors of sheltering under the Atkinson, which was a criminal case. That in this case, there is no doubt that, just from Kraft alone and the brief of Mr. Chhabra, was that he looks at just the Stisslinger part of it, the Stisslinger part where they found the driver slumped over the steering wheel. He says he was waiting there to call an Uber, but again, the holding of that case was that there is no issue of driving, and that's what the ALJ had found, that applying the Atkinson factors, that there was an actual physical control of the vehicle. What their brief doesn't, what their response brief doesn't go into was the Kraft portion of the two-part case, where you have even more extreme facts, where you find an accident scene, the trooper goes to the house, finds him passed out on his couch, strong smell of alcohol, and so forth. And again, this court held the issue of actual driving is not a factor in the refusal case. And I think that's where this ALJ was wrong and committed an error of law, and this court should reverse the decision of the administrative law judge.
Counsel, in this case, Officer Tucker did not testify. He was the arresting officer.
That's correct.
Okay. So in the normal case, you would have the DR-15 statement. In this statement that's here, is there enough here for the ALJ to have determined, without any extraneous testimony, that the officer had reasonable grounds to believe the defendant was driving?
Absolutely, Judge Green. That in this case, we have as I said, the strong odor of alcohol on the breath and the person. What he had gotten there for a trespass complaint. He had bloodshot, watery eyes. He had the slurred speech. All these factors. And yes, and where, again, the common sense that they'd gotten the trespass call, they'd come to this point, you found this man who was drunk texting, and there is no doubt that there is enough just from this. Now, Mr. Pollard exercised his right. He refused the standardized field sobriety test. He refused the preliminary breath test, the PBT. But I think from the four corners of the DR-15, there was enough.
In Kraft, wasn't the person passed out in his house?
Correct. That's what I said, Judge Watts. Yes, and that's exactly it. I mean, that was an even more extreme case, and this court said that was the officer had reasonable suspicion. If there are no other questions, I will sit down.
All right, thank you, Mr.
Thank you.
Merkin. Mr. Chhabra?
Good morning.
Good morning.
May it please the court. I think it's still morning, Judge, to your point.
Thank you. Good to know.
My name is Mandeep Chhabra, and I'm here on behalf of John Pollard as the respondent. I think that the court has made it very clear, based on the legislature's writing of 16205.1, that there's only four things that an administrative law judge is to look at. The reasonable grounds being the first and foremost, and that's why we're here. Administrative law judge Phillips made it very clear in her analysis, because we had the benefit of a full written opinion as opposed to what was offered in Kraft and the Stislinger case, where you just had the boxes that were marked in a very limited amount of information. Judge Phillips made it very clear that she did question the licensee, Mr. Pollard, regarding how he got there. We don't know anything, as Judge Green indicated, about what the trooper knew. We don't. The facts interjected about the trooper knowing that there was quote-unquote drunk texting going on, we don't know that from the trooper's point of view. There was testimony from Mr. Pollard that he was texting, but we don't know that the trooper knew that there was texting going on. The bottom line is that without having the benefit of testimony from the trooper or the witness that called for the trespass case, we don't know if Mr. Pollard had been at the home of his girlfriend the entire evening and they had a domestic dispute, went out to his truck, and he sat in the truck and went to sleep. When the trooper approached him, he was asleep, his seat was reclined, the keys were in the ignition, but there was no testimony whether the vehicle was on or the lights were on. The analysis that the judge did, the administrative law judge did, using the Atkinson fact patterns are not faulty, only because she used the Atkinson, which I would suggest is the criminal side of the Atterbury case. Basically, as practitioners looking at it, the Atterbury is the one that we would use in administrative law, and the Atkinson case is what we would use in the criminal case. The administrative law judge used those same factors to determine whether or not there was reasonable grounds. So it's important to understand that the distinction between the Kraft case and the Stislinger case. The Kraft case, the court ruled very clearly. Judge McDonald said that it was ambiguous, so we're going to send it back. We need more information whether or not there was reasonable grounds. In Stislinger, you found that the judge made a reasonable ground determination. In this case, we have an administrative law judge that parses out in her findings in fact, in the records extract, if you look at extract page number 23, that she parses out what she used to determine whether or not there were reasonable grounds to believe that this person had been driving or attempting to drive. It's the exact opposite. She finds very important the line that was introduced regarding the fact that Mr. Pollard, the licensee, when told to leave, said, "I'm not leaving." He was not going to drive away from the scene. So that is an important consideration in whether or not she was trying to find whether there were reasonable grounds to believe that he had been driving, how he got there, etc. It's important in the trooper's mind when he approaches, all we have is that he is showing up for a trespass call, nothing beyond that. And had the trooper been able to testify or shown up to testify, I should say, he would have maybe elucidated a little bit more to the administrative law judge as to what was in his mind. But based on the 5 lines that are there under the reasonable ground statement, there is nothing to indicate that the trooper had any reasonable belief that this gentleman had been driving or attempted to drive. In fact, it's the exact opposite. He woke up a sleeping driver. The sleeping driver had bloodshot and glassy eyes, and when he told him to leave the property, he refused to do so. The administrative law judge went on as far in extract page 59 to actually question Mr. Pollard about what exactly was going on. And she asked a little bit more about the context. So she was trying to get the context that she did not have from the trooper, the communication that he had with the ex-girlfriend. And that's where the texting comes in. That's where the information regarding texting comes in. But that doesn't determine whether or not the trooper, and that's what we're looking at, whether the officer, the investigating officer that arrived at the scene had the ability to determine whether or not there was reasonable grounds. The administrative law judge did the best she could in order to parse out whether or not she believed, based on the facts that she had in front of her, whether or not there were reasonable grounds, and she found that there were no reasonable grounds. I will agree that Administrative Law Judge Phillips just used in her verbiage that she was seeing this as a shelter case pursuant to Atkinson, which may have been proper to say she was using it as a shelter case pursuant to Atterbury, but that's neither here nor there.
Well, now, Atterbury was not in the end, was not a test refusal case.
That's correct. So the Atterbury...
And so that makes a difference in terms of whether the ALJ has to find that the person was driving or attempting to drive. It
makes a huge difference. I agree with you, Judge. But the bottom line is the facts that the court has asked to use to analyze are the same facts. Whether it's I think 6 actually fact questions in Atterbury that have been outlined versus 5 in Atkinson, but they're the same. They're just the verbiage is slightly different.
But therefore, they're not for a test refusal case. They're for a case where cases where the person took and flunked the chemical test.
I agree.
And so, it's not illegal under this statute to be drunk, but it's to be drunk and
possibly able to drive or attempting to drive. But the fact that an administrative law judge in that position, in order to parse out facts, is using a test that's been established to find out whether somebody has the reasonable grounds, the investigating officer had the reasonable grounds, is not inaccurate. It's just it's just a methodology she used to extract whether or not she believed the officer had reasonable grounds to effectuate or request a breath test in this case. And I think that sums it up. It basically comes down to this court putting themselves in the position of the administrative law judge who had certain limited facts in front of her, and she used an analysis. That analysis may have not been the applicable analysis based on the facts, but it was an analysis to determine whether this gentleman had been driving or attempting to drive. So regardless of what that she coached it in saying, I'm looking at the Atkinson facts. That's not the point. They're very much intertwined. In order to find out whether somebody has been driving or plans on driving, you can use those same questions to determine where they are, whether they're going to be driving, or the reasonable grounds.
Are you essentially saying that in order for the hearing judge to have the full flavor of what went on, Officer Tucker had to be there to testify? Is that what you're saying?
I think that if Officer Tucker had been there to testify, he would have been able to explain what was in his mind to determine the reasonable grounds. Perhaps Officer Tucker did know that there was a texting conversation, or he knew that the gentleman had only been there for 30 to 45 minutes in total, instead of sleeping for 30 to 45 minutes. If Officer Tucker was there to fill in those gaps, then we'd be in a different situation. Officer Tucker could come in and said that there was somebody that's seen him driving, and when I got the call, it was just a trespass call, and that's why I only put it in there. But we didn't have any of those things to fill in the gaps. So the administrative law judge did the best she could to fill in the gaps. And what I'm saying, Judge, is that she used questions that had been determined by this court to be appropriate questions asked for a different reason. I agree, but questions that would make a determinative factor whether or not somebody is driving an actual physical control.
Okay.
If there's no other questions, I will submit.
All right, thank you very much, Mr. Chhabra. Mr. Merkin, please reserve 5 minutes.
Thank you, Your Honor. Just briefly, I think that in this case, that I respectfully disagree with counsel that the issue is in a test refusal case, as Judge McDonald pointed out, is that actual driving or actual physical control is not an issue, and that this court has made clear, and that the ALJ made a wrong finding in this case. Your Honors, I'd ask you in this case, if you reverse this case and send it back, that it be remanded also with instructions in regards to the commercial driver's license issue that was never brought up with the ALJ, and because Mr. Pollard did have a commercial driver's license, there was no finding on the record of that issue. Okay. Thank you, Your Honors.
Okay, thank you, gentlemen. The court is now adjourned.
All rise.